that what should be done to better empower CCI to take actions is result in being effective deterrents. And then there's another question, is there a blanket rule of 10% penalty on violation of cartelizations? So let us deal with the first question.
Sure.
You see, the penalties have been imposed as we've seen to the maximum, that is 10%, we have seen that. Now, but have they been an effective deterrent? As I said, that the trade associations are actually feeling that their practice is justified because of the recommendation of the government, which I said the Ministerial Committee. And this practice has become so prevalent, and because of the non-opposition by the pharma companies, the trade associations are taking them for granted. So I think Commission cannot do more than this. Commission can only impose penalties. And Commission at the most can actually drag the individual office bearers where there are repeat violations, and we have seen there are repeat violations, to further penalties. And on non-payment, of course, they can face the news, they can go to even jail. So that is the only maximum deterrence which the Commission can give, which it has already started giving. So there is nothing more that the Commission can do. It is, I think, individually for the pharma companies to note that they should stop getting, dictates from them, and they should stop. In fact, it is the sector itself we can regulate, otherwise the maximum the Commission can do is already done. Now the second question, is there a blanket rule? There is no blanket rule, the 10% is the maximum which they can actually impose. And in case of cartelization, they can go a step further, it is 3 times the profit. So it's not only 10% of the turnover, of the average turnover, the CCI can go up to 3 times the profit, and we can take the example of cement case. In cement cartel case, they only impose penalty of 0.5 times the profit, and it was 6,000 crores. Imagine if it was 3 times the profit, 18,000 plus crores it would have been, companies would have been wiped out. So a huge sanction are there. Can we take the next question? So this is Subhash Singh from Trade Association. Do the drug controller and CCI have parallel jurisdiction? Madam, would you like to answer this? Very interesting.
So they are independent bodies, right, and incorporated under different acts. So they have simultaneous jurisdiction, and they do have a parallel jurisdiction, but it depends on where your cause of action lies. So obviously a drug controller is not going to look into a competition commission.
Absolutely.
And vice versa, the competition commission will not look into a DPCO or a violation of the Drug Act like we talked about Section 8. So while there might be some amount of overlap that you might see, but in terms of the cause of action arising, it will be with the different authorities depending on the cause of action and the violation.
And if I may add, ma'am, that the mandate of the drug controller is only to see whether there is a good and sufficient reason for the company to refuse. But whereas the competition commission has a wider role, because it can examine the effect on competition. There is an effect on competition because of that. Suppose that is the only dealer. Suppose there is a small town, and that chemist is the only chemist.
Right.
And just because it cannot afford to get an NOC from a chemist association for whatever reason, and if the pharma company doesn't supply to it, that particular area will not have any chemist. So this is a huge effect on competition, and that the market, the consumers suffer a lot. So the angle is wider maybe in the case of this. Of course, the drug controller can only look into the Section 8, that's it. Whether it is a sufficient cause or not.
Right.
Beyond that, but of course both are equally powerful.
Yes.
But I don't know whether the drug controller has power to impose penalties on the companies.
Yeah, so it's a criminal prosecution, right?
Okay.
So they'll go for the person who's responsible, and they have a penal provision to
under the drug control.
Act.
I see. So they
So
can
it's
be
more draconian in that
prosecution.
sense. Yes, there is a criminal prosecution as compared to just a monetary fine.
No, criminal prosecution can also be here if you don't pay.
If you don't pay, yes, but here it is, you don't even get the opportunity to pay.
So there is no fine possibility?
No.
I think fine is also there.
Fine in the sense, the court will determine what fine to pay.
So it's a prosecution.
It is both. It is criminal penalty as well as financial penalty as well as imprisonment. It is both under the Drugs and Cosmetics Act.
I see.
For different provisions.
I see.
So that is why it is more draconian.
Maybe, yeah, I agree. Okay, the next question is from a pharmaceutical company. Being a pharma company, should I not have the freedom to appoint as many stockists as I like? I think this you can also answer.
Yeah.
I think we agree with you.
Yes.
Because pharma company have they have their liberty. There's no control of their freedom. Please, ma'am.
Yeah. So actually, yes, the pharma company should have the right to decide whom they want to appoint as a stockist. But to Mr. Sharma's point earlier, that what you have to see is by not allowing stockists to be appointed, are you impacting any competition, or are you causing an adverse impact on in the industry is what you need to see. That is the larger thing that Competition Commission would look at if there was anybody complaining against not being appointed.
No, if I may also add to this, that not only the fact that you have the independence to appoint, you also can do due diligence, whether he is a person according to your own system or according to your own guidelines, fit to be appointed as a stockist, maybe for whatever reason. Second thing is that you please also see the geographical market where the chemist is associated, as I just now said, that if it is affecting consumers at large because of his non-appointment, then it is perhaps prudent for the company to see that aspect also, because that is where the competition law will trigger. Wherever the choice is restricted, suppose there are only 2 chemists and only one, so all those angles will come. There are so many possibilities in this. Though the pharma companies have all the liberty, there is no issue that they don't have the right to appoint their stockists as they want. As we discussed earlier also, that suppose your drug distribution doesn't need more stockists.
Correct.
It's already optimum. So in that case you can optimally, but then you have to justify to the authority whosoever asks you. This is the reason why we are doing it.
So there has to be a good and sufficient cause,
Exactly.
and as long as you can demonstrate what that cause is.
There has to be an objective justification which can be provable on evidence. That's all I can say. The next question is also from a pharma company, Mr. Chauhan. Are we dealing in mergers also? I'm sorry, Mr. Chauhan, I said in the beginning, M&As are out of this webinar today. If there is a response or if there is a more demand, we can take it up later on a separate webinar. There was a huge area of that. There is another question from Cuts International. No webcast, no video. I'm so sorry.
Yeah.
We'll have to look into it. I'm so sorry. We'll see. There is maybe a time lag. There is maybe a time lag due to which the webcast may have been delayed for some reason. But eventually, I think the streaming you will get it. That's all. So these are the only few questions we have got. And what do you think, Mrs. Vanjari? Shall we proceed to the next session?
Sir, more 2 questions.
Can you, please pass it on to us.
David,
Can you give me the email printout, please? No, this is related to this. Maybe you can read out if you want.
sorry.
Can you read out?
Yeah. Are there certain accepted industry-wide criteria for appointment of stockist?
Are there accepted criteria for appointment of stockist?
I think that answer you will.
Yeah, so there is
Who is the
nothing.
person who is asking this question?
DRL R Basu.
Okay.
R Basu.
Okay, so there are no mandated
Mr. Basu,
or
I think Meera ji is going to answer this question.
Yeah. So there are no mandated or no prescribed guidelines for appointment of stockists. Like we mentioned earlier, it will all depend upon your supply chain, your distribution channel, whether you need a person within your supply chain as to be appointed as a stockist. You will also look into a due diligence aspect of his financial viability, his standing, how compliant is he, what is his track record, has he been a stockist for somebody else in the past. Also, another very important criteria is about the storage system that he has within his godown or his area where he's going to stock your products. So if you have special conditions that you need for stocking your drugs and he does not have that available at his godown, then obviously he's not going to qualify for being your stockist. So there are many conditions which each company may determine basis their requirements with regard to their products, their storage capacities, their distribution channels, their supply chain channels. And it's for every company to at least do a due diligence and give the person an opportunity to be evaluated. I think that is very critical. And once the evaluation is done, you can go back and tell the person whether they are capable of being appointed or not capable of being appointed in the system for whatever reason you think fit, which should be a good and sufficient cause. You should be able to demonstrate it by way of evidence if called upon to do so.
No, can I ask you one question in this context only? I mean, perhaps what Mr. Basu wants to know is, are there industry accepted criteria for appointment? Now, criteria could not be, but there could be practices.
So the practices that,
Like for example, I just noticed one practice in our, advising the companies that they don't accept check.
right?
They will only accept DD because checks can be dishonored.
Yes.
And they don't have to run after those.
Yes.
So it could be an accepted practice maybe that only DDs are accepted as as good proof of payment, right? So this could be very loosely defined, but there are no hard and fast. Because see, the market is supposed to be competitive. Every industry, every company is supposed to devise its own guidelines and its own system of appointing a stock. After all, they are your agents, right? So you have to be.
So you will have your policies on how to deal with products which are returned back, expired
Right.
products. How would they be brought back into the system? Whether, like Mr. Sharma pointed out, whether you want to accept DDs or checks, Do you want payment in advance, or do you want payment on the date of the day the products are transferred to him, or will you give credit terms? Will you sell at retail price or stockist price? So there are so many things that will determine this.
Absolutely.
So it will all depend on company to company and the areas of the products that you sell in. One of the most important things is about storage conditions and how you can, whether they have the capacity to store your products.
That's right.
Because there are specialized conditions for certain products
Absolutely.
which they may not be able to provide.
And the medicine are also very many, that is another.
That's right.
Now the next question is very interesting by Mr. David Dartmoon from Omega Pharma. What is the full form of CCI? It appears Mr. David, you joined us a little later. This Competition Commission of India is what we are talking about. It is the fair market regulator of India, like what you have FTC in US or maybe the European Commission in Europe. The next question is from somebody from Competition Commission. Interesting. What are the appellate bodies in CCI Act? So the appellate body to Competition Commission of India is Competition Appellate Tribunal, and the next appellate body is the Supreme Court of India. So there are only appeal lies only to this compact, as we call it in short, and the highest is the Supreme Court. So that's it, I think, and we also come to the end of this question answer session because now it's 5 p.m. So we move to session 2.
Yes.
Okay. So now we go to the next session of the webinar, and it's very important session. So this is the session actually which will lead you to the reason why the CCI started, the Competition Commission started the sector inquiry into the pharmaceutical sectors. In fact, somewhere in 2008 or 2009. But before I go to the actual history of this, let me tell you something. Traditionally, whenever we all know the patents have a lifetime of 20 years. So when the lifetime of patent goes to expire, about to expire, see, there is a tendency to prolong the life of that patent. And there are very many methods which are used, but we come to that later. But what the evidence suggests is that innovative pharmaceutical companies lose up to 20% to 50%, from 20% to 50% of the market share when the first generic version of their drug comes up. And subsequent generic entries can cause prices to drop by as many as 90%. So this is evidence which actually has been gathered by European think tanks, and this is the reason which actually prompts or which is actually necessitating the kind of agreement which we are going to talk about and which led to the sector inquiry in Europe. So before the sector inquiry began, there were dawn raids, in the premises of both originator and generic companies by the DG Competition and European Union. And after the raids, the European Commission actually sent extensive questionnaires to more than 100 companies, both originators and generic, associations of doctors, patients and pharmacies, and also government agencies responsible for price setting the prescription drugs. And this year the questionnaire which I was actually talking about was CCI is contemplating in a particular area. So the same thing is what started in the Europe. And on the basis of those questionnaire answers which they received, they decided that there is a time to go for the sector inquiry. So the European Union actually conducted the sector inquiry in January 2008. The final results came out in July 2009. It was 1.5 years it took. And the inquiry examined the competitive relationship between the originators and generic companies and amongst the originator companies as well. That means both horizontal and vertical kind of arrangements were examined, and it made important policy recommendations aimed at ensuring an efficient and competitive pharma sector to the benefit of EU consumers. As we all know, European Union is a common market of nations, so they are very sensitive about the common market not being affected. And the final report actually suggested that, and this is the result of the inquiry, that behavior of the originator companies contributes to delay in introduction of cheaper medicines by generic companies. And the inquiry also showed that the originator companies use a toolbox, interestingly, to extend the commercial life of their medicines, leading to generic delays. So here we are talking of a situation that where your patent is going to expire, you are an originator company, but naturally you are used to a certain amount of profit. So who wants to lose a profit? So they actually employ so many methods, and what those methods are, I just described them. The tools used by the originator companies included patent filing strategies in several jurisdictions. And this actually, to be specific, it was something called a supplemental protection certificate, something called SPC, which gives up to 5 years of additional protection to in the Europe. This is a provision there, and this 5 year you can actually continue to charge the price which you are charging. And this was the typical case of AstraZeneca. And then there were patent related exchanges and litigations leading to settlements, oppositions and appeals to generic drugs before the European Patent Office. There was something called market authorization practices. Earlier in Europe, those were no longer there. And I'll tell you in a minute to tell you what these market authorization processes were. In EU, there was a generic, till recently there was a practice that the generic manufacturers were granted marketing authorization under an abridged procedure, provided the reference product was authorized in the EU and was marketed in the member state for which the marketing authorization was requested. It followed that the market could easily become foreclosed for generic companies to the extent that innovators decided to withdraw their marketing authorization. So if the innovator decided that I will not authorize this particular generic version, so that was a stop, full stop. So that also delayed the introduction of generic version. So that was another aspect. And then finally there were patent agreements and other secret agreements between generic companies and intervention before national marketing authorizations. That's what I just mentioned. And pricing authorities claiming that generic medicines are less safe. Why they refuse the product authorization was because they are not safe. Remember the Bayer case? Remember the Bayer case in India? Sorry to say, the Netco case is the same thing. They are less effective, they are inferior quality, and they will violate their patent rights. So these were the normal defenses which the originator company used to take there. And particularly of interest is the patent agreements. And this was the reason in the Servier case which we have quoted, which actually resulted in the dawn raids. And during this dawn raid, the commission found really the evidence of those side deals of those agreements. And that's why the huge fines were imposed, which we explain in the next slide. The generic delays, now this the next thing is very important. The generic delays are important as the price at which the generic companies enter the market are found as an average 20 to 50% or an average 25% lower than the prices of the originator medicine prior to loss of exclusivity. And at the moment the protection is going to come to an end, the prices start dropping.
And many players will come.
Yeah, because they know that the generic version will come.
Right.
So 2 years after the entry, prices of generic medicines were on average 40% below the former originator prices, leading to saving of the national health system. So these are the findings of the European inquiry, that up to 40% of the saving as an average, though it could be up to 80% in some cases, was made by the national health system because of the not introduction of generic drugs. So these were the two broad contours of the European inquiry. And then let us deal with these cases which actually resulted in huge fines little bit. Pay for delay. Now we come to this. One of the aspect of the European sector lesson, that there were pay for delay agreements. So what were the pay for delay agreements? We'll deal in this. But before I go to the pay for delay agreement specifically, let me tell you that there is already the pharmaceutical industry is under a shadow of past practices of cartelization also there. In fact, I wrote this article long back in 2009, Meera, just for information, which came in Economic Times, No Fair Play in Pharma Sector. This was an article I think in 3rd of November 2009. If you can Google, you will find out in the Economic Times. So that's where, and that was a time when Ranbaxy was raided actually, the company of Ranbaxy was raided in France because of the Servier case.
Servier case, yeah.
So that's when I wrote. So there is already we know the lysine cartel, there's a famous cases of vitamin cartels. So these are all cases which are, so as such the competition regulators all over the world, they have some kind of suspicious looking at the pharma companies for whatever the past has been. And in the EU, this AstraZeneca, again the patent sweetheart deals we call it sometimes. So these patent settlement agreements have actually resulted in huge fines, and this was the case of AstraZeneca. 60 million euro was fined on AstraZeneca for delaying the introduction of the generic version by filing repeated filings through the SPC and evergreening SPCs, etc. And then 2013, now these two cases are very interesting. Kindly see the next slide also. That is USA. In USA in 2017, June to be precise, 2013, the US Supreme Court in a landmark judgment in FTC vs. Actavis finally resolved the issue, holding that the pay for delay and reverse payment deals are subject to antitrust scrutiny. Earlier they were not considered as matter of antitrust scrutiny, but then for the first time on 17 June they had this, and the court, however, did not agree that the settlements are per se legal. They refused to say they are per se legal. They said they are subject to rule of reason. And within 2 days thereafter, very interestingly, kindly see the previous slide, the European Commission, I'm sorry, we want to go to the previous slide, how will you go? I'm so sorry. No, and should please go to the...
Second.
Yeah, it's there still. I'll
We'll just go back.
I'm sorry for this interruption. This. Now kindly see in 2013 the Lundbeck case. This was 2 days thereafter. So 17 June we had the Actavis case, and within 2 days across the Atlantic we had this case in European Union where the European Commission held that agreement between Lundbeck as originated in several generic companies to delay the entry of cheaper versions of the Lundbeck's antidepressant drug citalopram violated EU competition, and 9 drug companies were actually fined very, very heavily. And EU imposed heavy fine of 93.8 million euro on Lundbeck, and I think total 146 million, it's not 52.2 million I think, including Ranbaxy was also one company. So this was a huge fine, and EU actually observed in this, it is unacceptable that a company pays off its competitors to stay out of its market and delays the entry of cheaper medicines. Agreements of this type directly harm patients and national health system, which are already under tight budgetary constraint. The Commission will not tolerate such anti-competitive practices. So this is the very, very harsh and very, very strict stand which the European Commission took at that time, and this actually is continuing. So there is across the Atlantic the feeling is the same, whether it is in USA or in the European Union, which are the most prominent places of antitrust in the world. So these are the 2 places which the feeling is same. Do you have anything to say on this?
Yeah, so actually, you also have to understand why FTC or the European Commission come down so heavily on pay for delay agreements or stopping competition or generic from coming into the market, right? And one of the reasons, the biggest reason is because in these countries, the medical care is looked after by the government, so it is paid out of government budgets. So if medicines are not available at a cheaper price and generics are stopped from entering the market through different mechanisms, then there is a huge impact on the monetary budgets of the countries because of the pharma expense. So that is why it has a more deeper impact in those countries. In many other countries other than the US and UK, or like in India, here it is more self-pay rather than government.
Right.
But there it is more the government who provides for medical insurance.
No, particularly in the US, if you remember, Barack Obama, the president, had identified pay for delay as a top priority for the US government.
Correct.
As a part of US healthcare program.
Yes.
I remember in 2013-14. So that was the case.
So that's one of the main reasons why it impacts the authority, the government itself, and it has a monetary impact on them.
Correct. And there are some interesting facets of this also. There was something called authorized generics. In fact, the companies have now come of age, I would say, and they have devised more finer mechanism rather.
Yeah.
And one of them is what is called authorized generics. So how to come out of this pay for delay system, because it's a market necessity.
Right.
In a way, who wants to lose profit?
Right.
Although there is no justification for doing that, but at the same time, companies have invested hugely on the R&D and they have perhaps not recouped it. Fully, that could be the reason, because you see, the time the company starts actually getting a profit is very less, 3 to 4 years.
Yeah, so when you do research and development, innovator companies spend billions of dollars and they will only come out with one molecule which will hit the market, and the lifespan of that molecule being 20, even if you take it as 20 years or 15 years after they've
But it starts from the day the patent is given.
Yeah, from the patent.
By the time it commercializes, by the time it starts accepting the market, there are only 10 to 12 years already over.
Right, that's right. So that's the reason why innovator companies want to push out any entry of a generic.
Right.
And in the US there is the Hatch-Waxman law, which permits generic companies to challenge patents, because that is the way the legal system is set up there.
Yeah.
So obviously the innovator is at any point of time dealing with many generic companies who are challenging the patent for an innovator drug. And that's the reason they prefer to settle these matters, because it is better to settle them for a cost.
No, settlement is no problem. What the FTC looks at is the
No, but
side
even the
deals.
settlement, the settlement could be either you come in a few years before the patent expires, or this is pay for delay, where I pay you something on the side, have a side agreement.
That is what is actually subject to competition law.
And also the whole agreement is now, the FTC is looking into these aspects very closely.
Right.
And that is where the authorized generic comes in, because under the FTC laws.
In fact, US they call it market authorization, US it's called product hopping.
Yeah, so you are not,
Product hopping,
so your
actually.
agreements cannot restrain you, the innovator, from launching an authorized generic. The
Right.
innovator is free to bring in an authorized generic at any point of time.
Exactly.
Because this is for the pricing of the product, basically for the competition to determine the price.
Right. See, authorized generics, if I understand correctly, are products which are commercialized under a generic product named by a manufacturer of the original branded pharmaceutical, or by a generic manufacturer under a licensing agreement with the original
Yes,
manufacturer.
so,
So both can come out.
Yes, both
Is
can
it?
come out.
So
So the innovator will give a right either to the generic to bring out an authorized generic.
Okay.
So he's going to use the same approval, the same product that the innovator manufactures, but bring it at a lesser price.
But
and
will it
not
be
use
during the time of the
innovator-
patent itself or after the patent? I
No,
don't know.
during the time of the patent.
Okay.
During the time of the patent.
So it is mostly when the patent is going to expire, then they will come
Closer
out
to
with
the
this.
expiry term.
I see. That's what is very interesting. And then they can authorize generics for group strategy to secure competition in generic market for 20 years. So basically they try to not do actually patent deals, but they try to do this authorized generics, which is maybe a milder way, if you can say.
It's a So you cannot have an agreement which says no authorized generic, because that's anti-competitive in the US. So if the
Absolutely.
innovator is free to bring in an anti-competitive.
Then there are other practices such as co-marketing and co-branding also, which are now started being used by. So co-marketing, co-promotion agreements are also meaningful ways of cooperation between pharmaceutical companies. While the economic nature of both the agreements is intrinsically identical, the acquisition of the owner by the market authorization of the additional leverage of the market for a specific pharmaceutical, they are operating in substantially different ways. So there is something called co-marketing, that both of us will market it together, and there's co-promotion. So we will also promote them together in the market. So ultimately it is a horizontal cooperation between the companies. So it can be an issue of competition concerns because
Depending if there are any demarcations in territory and
yeah.
demarcations in
So there are hardcore restrictions which we'll just deal with later. And then there are something called commercialization agreements, and there is also called as specialization and joint production agreements. They're also subject matter of. In fact, in the US, not so much, but the EU has come out with very detailed guidelines. And just let me share you very briefly the specialization and joint production agreements. The EU came out with horizontal guidelines in 2010, and under those guidelines, they actually very, very carefully examined the areas which are permitted. Because they were actually cognizant of the market, what is called as you said, authorized generics and all those things. So apart from that, there was something called the new block exemption regulations came out for even R&D agreements and for specialized and joint production agreements. Now under this kind of category, what they did, they created a safe harbor. And the safe harbor what? That these rules will exempt certain specialization and joint production agreement from the scope of Article 101 of TFU, that is equivalent to Section 3 of the Competition Act, covering three aspects. One was the unilateral specialization aspect, when one party agrees to seize and refrain from production of a product and to purchase it from other party, which in turn agrees to produce and supply that product. So I will not produce it, you will produce it. And then the second, reciprocal obligation, reciprocal specialization agreement, where two or more parties agree to seize or refrain from production of specialized but different products on a reciprocal basis. And the third was joint production agreements, where pursuant to which two or more parties agree to produce certain product jointly, say by way of joint ventures, right? So, but these all three agreements were actually exempted only when their market share of both the parties in different markets, each market did not exceed 20%. So 20% is the cap.
Is the cap.
Safe harbor. So if your combined market share of all the parties, two parties combined, does not exceed 20% either market, so then it will be exempted and you get a block exemption.
Right.
In Europe we got an exemption rule under 101(3) that their agreements can be exempted from antitrust code. But then there were hardcore restrictions, as you rightly said, that even if your market share was below 20%, but if you are indulging in these 3-4 things, then the exemption will not come. And what were those hardcore restrictions? Price fixing vis-a-vis third parties, except price is charged to a direct customer. You got a charge to the direct customer. The limitation of output or sale, and then allocation of markets or customers. So if you select customer or you allocate market, then this exemption will not be applicable. So these were the kind of 4 allegations, 4 kind of hardcore restrictions which were not permitted. So after having said that, I can also like to share with you that as per FTC reports of May 2008 again, such reverse settlement, let's see the US scenario a little bit. Between 2000 to 4 there were nil. There was no such agreement in US.
Okay.
And then in 2005, 3 such agreements were noticed by the FTC. And in 2006, 14 agreement came. And 2007, 33 agreements. So progressively these agreements are actually increasing. That's why the FTC became more harsh, you know.
Yeah.
So that's the reason. So as per the FTC report, the agreement included side deals as we were discussing. That is supplementary obligation and not directly related to the resolution of the patent dispute.
That's right.
Typically, such side deals provide for compensation, cash compensation directly to generic companies and an agreement to delay market entry. And as per FTC, such side deals are they call sweetheart deals they call it.
Are also
Actually estimated to cost US customers about $3.5 billion per year. That is in 2014, and it can go to $35 billion in the next 10 years. So huge, impact is there on the economy even of the United States. That's perhaps the reason that the both sides of the Atlantic these deals are being looked into. Though European Union has by now evolved more and has come out with guidelines which are I think very helpful to the companies who want to save their profits. So that actually almost brings us to the last slide of this day, and that is this. Now what is the way forward? As we were saying that we'll discuss it briefly. The way forward is what? All this entire discussion, if you've seen, we discussed the CCI, you see the competition issues in CCI India so far.
Yeah.
We also saw the competition issues abroad in the major mature jurisdictions. And what comes out is that anywhere where there is either a horizontal cooperation which is leading to the restriction of the choices or to the increase of prices, ultimately it's all on the consumer. Effect is very important.
Patient effect.
Yeah. So that is very paramount in the mind of the regulators. So what is perhaps as far as India is concerned, we can perhaps suggest a few steps that you should adopt a better liaison with your C&F agents to avoid refusal to supply even due to omission. Because at times what happens is that because of the past practices going on,
Yeah.
your C&F agent maybe because of thinking that's still going on, it says that well you get an NOC because he's used to it. So
Right.
please have a better liaison with them. And then publish periodically and strictly enforce your policy guidelines for appointment of new chemists with chemists and trade associations actually. Coming to the last mile, in fact the pharma companies according to me should go to the last mile, go to the smallest level of chemist association and say, "Bhai, we have these guidelines. So if anybody approaches you, so please circulate him this, that if he fulfills this then we'll appoint him." So that's one thing which you should I think ideally do. And then periodically disseminate the information through internal circulars, orders in your sales, marketing, distribution teams, not to yield to any pressure from any chemist association because mostly it comes at the lower level. It won't come to a top level person. It won't come to a general counsel straight because it will come to a sales manager maybe.
Right.
This is what we have experienced. Not to yield to this thing and in case of repetition to inform the legal managers immediately and avoid any direct communication with the new chemist seeking appointment as a stockist. And also inform in case it really is persistent, then I would advise that the company should go and inform the CCI. In case any chemist association boycotts or obstructs supply to any and does not for not obtain claims. If a real case like that comes, that is adamant, then I think the best thing discreetly you go and file a letter to CCI. You can consult and you can straight away go to the CCI. But that's what the view in LKM the CCI's views. That if they were actually not facilitating, they should have come to us. See, CCI is for everybody, mind you. CCI is not for the small companies, even the bigger companies come. And I have this example of Reliance. The Reliance industry came to CCI against whom? Against the petrochemical and the PSU companies, HPCL, BPCL and IOCL. There is a case going on. They said that wherever in Gujarat we are bidding, because they also there are old fleets, these people are colluding. They are giving very low prices, so we are out. So they actually, so it's a company like largest company in India has gone. So what stops? So it's actually this is a tool which you can use. So that's just trying to say. Then similarly, you should also seriously consider, a competition and compliance program, including a competition law manual within the company, which will, and you should undertake actually periodic trainings by expert, and your distribution agreement particularly, and also your co-branding and co-promotion agreements also if you have, and because we have come across such agreements which are actually now in vogue, even in India, and the commercialized agreement, your R&D agreement for example, your technology transfer agreement, they should all be examined once, so that they don't have any competitive restrictive clauses. So that's, we come to this session. Now let's see the question answer. Some have come. Have we some questions?
Yeah.
These are the two questions.
Basis, yeah.
This is all
These
done?
are all done.
Oh, thank you. So this is also Daniel S. No, mergers in pharma sector, as I said, we have not kept in this webinar. So this is out. Maybe we can, if you send an email to me, maybe perhaps I can answer you separately. And then Mr. Rahul from IPPA. Are there any ongoing investigation for pay for delay agreements in Indian landscape? And how would such agreement be dealt by CCI? Very interesting question. In fact, see, as I said in the beginning of the session, there is a whole background to this sector inquiry in India, which has already started, or which is actually the process has already started for the sector inquiry. And maybe the CCI is having those agreements which have been reported in the media in mind, but they cannot go after the company till they have some evidence. So the sector inquiry which they are starting would actually collect that evidence in a limited way. So as of now, to our knowledge, there is no such case which is going on for pay for delay in India. But if such agreements and how they will be dealt with, European model, European experience is already there. We suspect that huge fines will be imposed if such agreements are there, because ultimately they restrict in the loss to the consumer.
That's right.
So then there is a question from Mr. Ajay Gamble from Vodafone. Has CCI dealt with pay for delay agreement, or is it investigating? I have already answered that question, Mr. Gamble. That not to our knowledge, but it can come. And I gave you two examples of what media reported, Hoffman La Roche and I think Merck and Glenmark. So these two are, I don't know whether they are right or not, but this is the media which has reported. And there's somebody from Exxon. Medicines are extremely expensive. Please let us know what CCI can do about the same. Well, as far as the medicines being expensive, see, our view on this is that Competition Commission of India, though it can deal with excessive pricing under Section 4, that is abuse of dominance, but then a dominance of the company has to be proved, which is a very, very ticklish thing to do. It's not easy to prove dominance of the company, but there are many companies who are competing. So what is dominance? Test of dominance is that being capable of behaving independently in the market, independent of competition, which no company can do. You have to take care of competition when you're behaving. So the CCI actually, legally, yes, they can deal with expensive medicines, but technically speaking, generally speaking, it is something which is outside the purview of the competition, right? Because for taking care of the medicines prices, there are regulators, there are other price regulating bodies, NELP and all, maybe Meera can answer that. So can you answer on this one more?
Yeah, so see, in the generic market, there are many generic players, so really CCI is not going to get into this pricing issue. Because like Mr. Sharma also mentioned that you have to prove dominance by one player, and in a generic space there are many players for one particular medicine. However, when it comes to products like anti-cancer drugs or anti-HIV drugs, which is a niche area, and maybe there are just 2 or 3 companies or maybe even one company who is operating and the prices are very high, if CCI receives any complaints or finds out Sumomoto that pricing is very high and there is no real reason for it, they might be well within their right to inquire. But having said that, the authority under the law today is under the Drugs and Cosmetics Act with the NPPA, National Pricing Authority, to fix drugs. And you must have read in the last couple of days, they are in the process of limiting the prices by way of a ceiling price on many drugs. Okay, so that move is already on by the National Pricing Authority.
So NPPA, I think next policy is also coming out.
The policy is already out, in which they have.
Which year it came on?
So the DPCO has come out with a policy in 2013 with an NLEM list.
Okay.
And the last month they came out with another new NLEM list, wherein they brought in many more medicines under the purview of NLEM.
No, but perhaps the question could be about non-DPCO controlled drugs also.
So non-DPCO controlled drugs, which are non-scheduled drugs, already have a limit of 10% increase only.
How?
Under the Act.
Achha, they prescribe the increase?
Yes.
Cap?
Yes.
Is that cap prescribed?
It's a cap.
Then they are very well regulated, I think.
It is regulated indirectly. It's not really open to.
No, but what about this 10% margin or 20% margin which the chemist association tried to
enforce?
Those
are fixed. But that has got nothing to do with the pricing of the drug. The pricing increase. Today, if my drug is at an X price, a year down the line, I can take only one increase up to 10%.
That's inside the Act
itself. Yes, it's prescribed in the Act for scheduled drugs.
It's interesting.
For
So there's hardly anything which the companies can do without the government's knowledge, I think. And then this I think we've already answered. Medicines are expensive, this has also gone. So with this there are no more questions, I think. And we can wait for 5 minutes maybe for having more questions. See if there are more questions, because we have still time. If there are more questions, we can take on more. No questions?
No questions.
So I think with this we come to the end of this webinar. Thank you very much participants for joining us and for being with us. I hope you enjoyed. We actually appreciate your feedback could be given to us on the email which we have given. This is the email ID. Just a minute. How do I? Yeah. You can note down my email ID please. If there is any question you can share it with me. I will be happy to answer it.
Just read out your email address.
This is mmsharma@vaishlaw.com and you can send it to me. I will gladly reply to that. But excluding the merger and all questions, of course you can ask me that also. But as far as antitrust is concerned, we have tried to cover all the aspects and I hope it was useful for all the participants. Thank you very much.
Thank you, Mr. Sharma.
Thank you ma'am, thank you for joining us.
Thank you for the opportunity.
It was a pleasure to be with us and to